Welcome to American History Notes, where I discuss with you things I've learned about American history and conclusions that I've drawn from my studies. Conclusions you don't have to agree with necessarily. I believe anybody necessarily would, but you should at least know about these topics to be a conversant in American history. So we're going to begin today. We're in a series of talking about crime, punishment, and the law, how it's evolved in the United States from the colonial times. Now, from what I talked about yesterday or last time, criminal process changed, of course, over time. The use of the jury increased over time, and in Maryland in particular, became a regular institution. The Puritan colonies eventually accepted jury trials as well, although the practice varied from colony to colony. In Virginia, from 1711 to 1754, the historians I read report very few jury trials, with most defendants pleading guilty and submitting to the court, expecting mercy and leniency. Only 6 out of 200, quote, put themselves upon the county or asked for a jury. The jury was not supposed to be a blank slate at that time or completely impartial, but simply local men who knew what in their area. The jury today is far more independent than it was at that time. The judge dominated the proceedings, and the television courtroom dramas you've seen, while mostly false for today, are completely false with regard to yesteryear. Most colonial trials were brutish and short. First, if you were there, would notice the defendant would have no lawyer. Most defendants couldn't afford one anyway, but that didn't matter as the accused wasn't allowed to have a lawyer. Early Virginia law had juries taken from the neighborhood where the crime was committed, but in the 1700s, the jury began to be picked in a more impartial manner. In South Carolina, by 1731, jury names were to be drawn out of a 6-drawer box by a child under 10, and the names were to be placed on pieces of paper of equal size. Colonial justice was pretty amateurish. It was run by amateurs, and today's professional class of legal people simply weren't around. In the 1600s, lay magistrates decided the cases. There were no police in the modern sense. The local sheriff was in charge of law enforcement, and he summoned jurors. Constables made arrests, and night watchmen patrolled the streets in bigger towns. Constables and watchmen were, for the most part, ordinary citizens, as it was considered a man's civic duty to serve as a constable or watchmen. Of course, not everyone had a sense of duty, and certainly not enough men to make the system work for long. The Dutch introduced a paid watch system in New York in 1648. One was put into effect in Boston in 1663. However, both towns abandoned the idea later when it became just too expensive. So the night watch continued on an amateur basis. The New York watchman's duty in 1698 was to go around the town with a bell and call out the weather and announce the hour, and if anyone was caught lurking about up to no good, the watchman would take the reasonable efforts to grab that person or persons. The sheriff was a familiar figure in the various colonies. Governors appointed sheriffs for each county. They weren't elected officials yet. He enforced the law and acted as the government agent in that county. Not only was he in charge of jury selection under English rule, but he had charge of jails, prisoners, and their care. In Pennsylvania, some sheriffs enacted fees from prisoners, and statutes of 1730 prohibited sheriffs or undersheriffs, that's a deputy sheriff, from extorting money from prisoners and forbade them from selling alcohol to prisoners. Next to the magistrate, constable, and sheriff in the colonial framework of criminal justice was the office of coroner. This was an ancient institution brought over from England, and he conducted inquests in cases of violent or unexplained death. A specially selected jury would view the body under his direction and decide whether the death was an accident, suicide, or murder, or whether, in the words of one New Hampshire statute, one, quote, died of felony or by mischance and accident, and if a felony, whether by his own or another's, and if by mischance or misfortune, whether by the act of God or man. And if he died of felony, who were the principals and who were the accessories? That's quoted from the 1718 Laws of New Hampshire and Friedman's Crime and Punishment in American History. In England, there was no such thing as a district attorney, a paid official whose job it was to prosecute crime on behalf of the state. People were supposed to prosecute on their own and at their own expense. Early on, the public prosecutor appeared in America. This idea was gotten perhaps from the Dutch, who had an officer called a scout, who was a sheriff and a prosecutor, although historians are divided over the validity of this Dutch influence. I meant to say in New England, there was no such thing as a district attorney. So, in any event, we're going to continue talking about criminal justice and colonial religion as well, how they're intertwined. And I hope you'll study. Disagree with me? That's fine. That's fine. I hope so. I hope you at least, that means that at least you're thinking about it and you're studying it. So thank you for listening. Bye.